You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. This series is hosted by litigation attorney Dan Small and is based on a long-standing article series he co-authored with United States District Court Judge Dennis Saylor for Massachusetts Lawyers Weekly. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
To try a case effectively, you need to have a theory of the case, and you need to develop themes to help persuade the jury. Although they're both important, they're not the same, and they both need to be considered carefully. First, the theory of the case. The word theory may be misleading. It's not conjecture or a hypothesis. It's a shorthand way of describing what you believe and will prove that happened. A theory might go like this. The defendant doesn't dispute that Mrs. Jones was attacked and robbed and that she's an innocent victim. However, he was not the one who did it. He was not there. He was at work 8 miles away at the time of the attack. Mrs. Jones' identification of him is simply mistaken. A theory will help focus your presentation on things that matter. For example, whether the victim's vision was impaired, and help avoid wasting time on things that don't. For example, whether the victim should have taken more precautions. The facts that you develop should help prove the theory. Don't elicit facts without a clear purpose. A successful theory needs to be reasonable, or at least plausible. If you can't come up with a reasonable theory, maybe you need to settle the case and move along. Remember that your opponent will have their own theory of the case. Don't just ignore harmful facts. Your theory needs to take those facts into account. Next, themes. A theme is a core fact or core conclusion that you want the jury to focus on during trial. Usually a theme is grounded in facts, but sometimes it's purely argumentative. Even a simple trial may have dozens of stray facts and arguments, and you want to make sure the jury remembers your key points. In my most recent book for the ABA, Lessons Learned from a Life on Trial, several of the stories involve a case I prosecuted involving a grain elevator that exploded, killing 18 people. I discovered after talking with friends and family that they didn't understand the basic facts of the case. Grain dust is highly dangerous. When most people hear the word grain, they think bread. No one fears walking down the bread aisle because the bread loaves might explode. They won't. Yet the reality is that grain dust suspended in the air is 5 times more explosive than coal dust. That fact became one of my core themes. Grain dust is 4 times or 5 times more explosive than coal dust. Everything, argument, testimony, experts, demonstrations, focused on helping the jury to truly understand and accept that fact. When developing your themes, bear in mind these cautions. First, facts come first. A theme is useful if it helps to explain or interpret facts, but it's not a substitute for evidence. Next, themes by their nature are simplistic, but if you oversimplify, your credibility may be undermined when the facts don't line up quite so neatly as your theme would suggest. Next, beware of the overly argumentative theme. You may think that corporate greed or systemic racism is a winning argument, but others may be put off by it. If the facts really are that powerful, they can speak for themselves. Next, themes can sound gimmicky. Reducing your case to a catchphrase may sound a little too slick, and more so the more often you repeat it. You're not selling a product here, and you certainly don't want to sound like a salesman. One way to conceptualize these issues is to use the STEM questions protocol from the field of education. According to that protocol, any effective presentation must answer 3 basic questions: what, so what, and now what. In the trial context, what means What happened? What are the facts? The next one, so what, means why does it matter? What difference does it make? And the question, now what, means what do you want me to do about it? You need to supply the jurors with clear and coherent answers to those questions. Don't leave it to them to puzzle it out on their own. Trial lawyers like to talk, but when you're preparing a case for trial, it's far more important to listen. Find opportunities to tell your story to your family, friends, co-workers, strangers in a bar, people at the gym, and pay attention to how they react and listen carefully to what questions they ask. Then rework it and tell it again. Too many lawyers don't do enough to keep their points focused, simple, and understandable. It's very easy to get lost in the weeds, and it requires constant effort to stay on point and communicate effectively. Come up with a clear, reasonable theory and develop clear, reasonable themes to support it.
Thank you for listening to the Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Daniel-Small.